Breaking news, breaking news, breaking news. P. Diddy had court today. They offered him a plea. Diddy said he don't want to have nothing to do with it. He's going to trial, get him ready, line him up. He'll rather be judged by 12 than carried by 6. Let's roll the dice, he said. That's where we at. Sit back, enjoy the ride, and know what time it is. All right. All right, let's keep it moving. All right, now, P. Diddy went to court today. We're going to play this out so you can hear what happened in court. Y'all put it in the comments what y'all think about how P. Diddy handling this, and we're going to keep it moving.
Something came up today about a defense, right? Something, the swinger defense?
Yeah.
Is that give us an idea of, you talked about consensual sexual relations, which I think is going to be their main argument, that all of this was on the up and up, but what is the swinger defense exactly, if I'm understanding correctly?
Yeah.
That's just saying that he was a swinger. He knew what time it was. He wanted to get his rocks off, and he paid for, professional service that was legal and, tested and clean and everything else. That's basically what he's saying. Okay, let's keep it moving.
It seems like that was something that Mark Agnifilo just kind of put out there, really.
Okay.
It was when the judge was addressing the motion to preclude evidence, which the judge did grant. And this was a government motion, by the way. And it was about other couples who, bring in escorts into their private endeavors. And the defense says, though, that it's relevant just about the intent of this.
See, basically he's saying everybody do it. Everybody bringing escorts. Everybody in our circle, this is what we do, but you're holding me responsible for what we all do, and we don't know it's criminal. So as long as we don't know it's criminal, we're not breaking the law, even if it's criminal. Because you have to know that you're breaking the law. That's why, because we riding. That's why they take you for what they call, those psychological evaluations to see if you capable of standing trial in a sound mind. Because if your mind ain't right, you not going in no trial. Oh, happy Friday and gunshots to you. Okay.
And so Mark Agnifilo was making the argument that Combs, the defendant, might think it's appropriate to partake in this type of lifestyle because other people do, other swingers do. I remember, covering this case, we all have covered this case so much. And I remember asking one of our legal analysts, is sex on trial here? But it seems like the defense all along, their defense being that the sex was consensual, that everyone was a willing participant. But to me, it's always just that one moment that someone doesn't want to participate, doesn't want to.
Do you think that sex is on trial here? Put it in the comments. Let me know.
Be a part of it. But that makes it kind of the grounds of a little gray area here where I'm sure jurors will have to weigh in this decision. But as far as just the swingers go, Mark Agnifilo kind of made it clear that Diddy was a part of this lifestyle. It's not unusual for him to hire escorts. Other people do it. Other couples do it. And so the defendant may have not thought that this was criminal behavior.
Didn't I tell you?
This is what I find interesting about it, right? First of all, he is not steering away from the idea of the freak-offs. They seem to be saying, these were called freak-offs. We're going to call them freak-offs, but they're not illegal.
Yeah.
But one of the charges he faces is transportation to engage in prostitution. If he's saying, I hired sex workers, but if he's transporting them and paying for them, I feel like it's going to be very, very difficult to argue he's not guilty of that charge. We talked last time about how he tried to get it dismissed from the case, basically saying it's a racist charge, but it's going in.
Yep.
So I'm curious to see about that. Okay, a lot more to get into about what happened here. Something about a medical procedure. Let's start there. I hadn't heard anything in the prior filings about a medical procedure. Was this about Diddy, or was this about one of the alleged victims? Talk to us about that.
So initially, I was kind of thrown off by that as well too. Or like a motion about a medical procedure. I was like, oh, does Diddy have to go through surgery in the middle of trial? That's where my mind went to. But pretty much, it was a government motion that was granted. I just want to go ahead and spoil that there. But the government argues that they want to put in evidence of coercive control. They say it kind of goes to the whole consent issue. Obviously, that's going to be a big issue when it comes to trial. They say that as far as the medical procedure, which by the way, they didn't specify what the particular medical procedure was, or even what victim it had pertained to, alleged victim it had pertained to. But the government argues that it goes to the harm of this type of sexual activity. They say that it's relevant to the sex trafficking charge. Again, unclear what the procedure is, but they say that the procedure was a result of the sex trafficking claim. And so they're going to confirm more particularly about this in the next hearing, which is next week. But for right now, the judge did grant that motion.
Again, I have no idea what it is, but it sounds to me it could be one of these alleged victims who say, I mean, maybe I was forced into this sexual event, this sexual episode, and I had to maybe get an evaluation of some sort. I mean, that's a possibility, but that's interesting because that's the first time I think I've heard and you've heard about a medical procedure.
And even in the indictment, they're laying out, the maybe IV fluid. Yeah, exactly. The IV fluids that were laid out in the indictment.
Oh, that's interesting.
So, maybe it is also kind of pertaining to just how hard allegedly participating in these events that you don't want to even participate in the first place, what it does to your body. And it looks like that'll be a topic of discussion.
Because they talk about prolonged sexual activities, drug use. So again, we won't guess what it is, but we'll see. Okay. I want to move on to a big issue. And I'm going to lay out a little bit of the context here, and then I'm going to jump back to Elizabeth. But this pertains to the infamous 2016 footage of Combs allegedly beating Cassandra Ventura in a hotel hallway, more specifically the Intercontinental Hotel in Los Angeles. And we believe Cassandra Ventura is victim one in the indictment. And the prosecution wants to introduce this evidence to prove sex trafficking, that there was a sex worker in that hotel room from which Ventura was escaping, the evidence of the infamous freak-off, or one of the freak-offs. And again, let me lay this out, what the arguments are. So in a previous filing, Combs has been trying to have this evidence excluded from trial. Obviously, he doesn't want a jury to see this. One of the arguments he made was, quote, there's no longer any dispute from the CNN footage from March 5th, 2016 at the Intercontinental Hotel, offered by the government at 3 separate bail hearings, is wholly inaccurate, having been altered, manipulated, sped up, and edited to be out of sequence. As indicated below, CNN paid Redacted, don't know who this person is, we can guess, Redacted for footage, copied that footage in unknown ways, presented that footage out of order, and destroyed the original. Accordingly, all the footage from CNN is inaccurate and inadmissible. As for the 2 items of footage filmed by an iPhone 6, those pieces of footage are inaccurate and inadmissible as well. And then they go into reasons why. Now, apparently someone took cell phone videos of that footage too. And Combs' defense argued several points, like the CNN video and the iPhone videos have to be excluded because the government can't provide sufficient evidence of their authenticity. How can you prove what you're purporting it to be? The defense argues that none of the files at issue are the actual originals, even though they make the argument that they made a good faith effort to find the originals. That the probative value, so their relevance at trial to prove, let's say, sex trafficking, is outweighed by the risk of unfairly prejudicing the jury. The jury seeing this footage and all the problems allegedly associated with it, whatever relevance it has, it's outweighed by all that. Now, in a recent filing from the government objected to all this. They argued, for example, it is by the defendant's own hand that the original version of this damning footage no longer exists. It was deleted and given to the defendant as part of a cover-up orchestrated by the defendant and his co-conspirators. The court must not reward the defendant for his actions by precluding the video that remains available despite the defendant's obstructive efforts. And that goes to the allegation that he paid for the footage and hid it and all that. And I thought this was also an interesting response to the argument of authentication. The government responded in a filing. The defendant himself also authenticated the content depicted in the videos. Following CNN's initial broadcast of footage from the Intercontinental Hotel, which, by the way, we all saw last year when CNN published it, the defendant posted a video on his Instagram in which he admitted that he was in the video and apologized for his behavior depicted in the video. At no...
Right there. That's where he lost. See all that? That's why I let it play out. Wanted you to hear it out. He sounded real good. He was on a ride. He was on a ride. And he's saying it's not the tape. It's not authentic. It's not this. It's not that. But then why did you go apologize for the actions in the tape if now you're going to say that the tapes, you know, is not authentic? But you gave a authentic apology. And that's why, like, when Big U gave that speech before he went in, they're going to twist that and use that in their favor. The same as they use Diddy's apology right now in their favor. This is the way it works. Don't get involved in crime. It's not worth it. It's not worth it. It's not worth it. All right, let's keep it moving.
No point did the defendant dispute the accuracy of the video or the events it depicted. It's a good point. And also, they say, the defendant raises a variety of potential issues with the available videos, ranging from their playback speed to their timestamps, which he claims makes the videos unreliable. Not only are the videos reliable, but the defendant's concerns are relevant only to the weight the evidence is accorded, rather than the video's admissibility. In other words, meaning allow the jury to decide what value to give these videos. Don't just not let it in. So, Elizabeth, I laid it out. What was the discussion regarding this 2016 footage, which I will go on record as saying I think arguably the most important piece of evidence? I say that I don't know what the rest of the evidence is, but from what we see so far, what was the discussion regarding that footage, and is the judge going to allow it to come in?
Yep. Well, it looks like yes. I just want to spoil it for everyone. The judge is allowing this CNN video to be played, so we are going to see it. And just even taking a step back, there were a lot of moments throughout our coverage of this entire legal saga, from Cassie first filing her lawsuit, it was settled. But there were two moments outside of Diddy's arrest that were humongous in this case. One being his homes being raided by the feds. And then also when this video came out. This video is huge. A lot of people have seen this video. And the prosecution, the government has long said that this piece of evidence, the video, is critical to their case. Obviously, they want to use it. Remember just how everyone's speaking of this video, or even just of Diddy's legal battles. They were, just women want to take him down, women want to take him down. And then everyone kind of just flipped their opinions once this video came out. And so the video will be admitted into evidence. And it was interesting, the government's kind of response to this, which obviously they wanted this video in, but they do have a video expert who adjusted some of the video. The government expert was able to slow it down, because when we saw it on CNN, it was sped up. I don't think anybody, you don't need a degree in video production to know that that video wasn't in real time, or at a normal speed, I should say. But the expert has also lifted the cell phone video as well too, and kind of were able to correct it. So the video will play in a normal speed. It won't be the same video that we had all saw blasted on CNN. And as far as what the judge had said, he had pretty much ruled the remaining footage will be used with witness testimony, or actually this was what the government was saying, that the remaining footage will be used with witness testimony who can say that the video is accurate. And to the government's point, and what you had just read in their letter to the judge, they say the video is accurate. Diddy came out with that apology video where he had apologized for his actions because of the swift backlash that he was receiving after this video was made public. And the judge also said that the probative value was not substantially outweighed. And so, how a jury will actually react to seeing the video in a normal speed, it'll be up to the jury to see what their thoughts are about it. But just even the depiction of it, it's ingrained in my brain.
Hold on, man. Hold on. Did you hear this? Do you hear this crap? What difference does it make if that tape is played in fast motion, slow motion, reverse motion, upside down, drop, flip, dirty curl, Russian split speed? That's your damaging. How fast or slow does it have to go to show him picking his foot up, putting it on the woman? That right there is like putting a thumb on the scale, as they call it. But that's what happened. That's why I say don't get involved in the life of crime, because it's not worth it, so you don't have to be put in that situation. Because they talk about, we're going to let them play, but we're going to, let them run at normal speed. Even normal speed, it looked crazy. Come on, man.
Things about that. So one, we know the defense is probably going to characterize this as just a domestic spat. It's an unfortunate domestic spat, but not evidence of sex trafficking, that it was maybe Cassandra Ventura catching him cheating or something like that. Did they say anything about the iPhone videos more specifically? Because I think, didn't they say the person who shot the iPhone videos of the surveillance footage is going to testify? And I wonder Is that victim one? Is that possibly Cassandra Ventura? I don't know.
Yeah, that part is a little unclear, but the government does have that cell phone video. And so again, they're going to kind of piece together, one, in normal speed, the surveillance video that we saw, but also the cell phone video as well too. Unclear on whether or not it was taken by victim one or if it was somebody who had taken a video of this, so that part's a little unclear. It's a little dicey for me to explain right now. But the hugest part of this is that it's going to be admitted that a jury will see this, whether or not a jury can believe that equates to sex trafficking or just alleged assault is two different things. And I guess we'll see once trial comes.
It's a really important piece of evidence. Okay, so now I want to get into expert testimony, and this is important, and I'm going to lay this out again, and then we'll talk about it. So the next part that came up was about the testimony of prosecution witness Dr. Dawn Hughes. We've discussed her before. She is a clinical and forensic psychologist who actually testified, by the way, in the Johnny Depp Amber Heard trial. The defense objected to her testimony. In fact, here's how the prosecution described what her anticipated testimony would be like. And this is from a recent filing. The following includes the anticipated opinions the government expects Dr. Hughes will offer regarding sexual abuse and victim responses to sexual abuse, coercive control, coping strategies during and in relation to sexual abuse, delayed disclosure and memory of sexual abuse. All important to understand maybe why the alleged victims did or did not do what they did in this case. And it went on to say that the government expects that Dr. Hughes will testify about coercive control as a tactic of victimization, i.e. the state or process of becoming a victim, and a strategy to gain dominance across a spectrum of relationships. Coercive control, they say, often includes a variety of physical, sexual, and/or emotional tactics that together function to control the victim, such as actual or threatened physical violence, aggression, sexual assault and abuse, sexual degradation, financial and economic control, control over reproductive health, control through the use of drugs or alcohol. This almost mirrors a lot of the allegations from the indictment. And in another recent filing, the prosecution said, quote, Dr. Hughes is expected to testify that interpersonal violence is violence or abuse committed between individuals, including rape, sexual assault, sexual harassment, or intimate partner violence, among others, and also refers to dynamics related to coercion and emotional abuse that may not necessarily involve physical violence as commonly understood. Dr. Hughes will not purport to explain what coercion is under the law applicable to this case. Rather, she will explain the concept of coercive control as understood within academic literature and within the practice of psychology. Throughout her testimony, Dr. Hughes will make clear that the terms she uses and the concepts she explains are all used within the field of psychology and are not legal terms or definitions. The reason that's important is because the defense objected to this. And in one of their filings, they said, Hughes also proposes to testify about what coercion means in the context of her discussion of the concept of coercive control. And her definition is different from the legal definition. According to Hughes, coercive tactics can include not just violence and threats, but a variety of other subtle tactics, including ostensibly positive behavior such as rewards, positivity, affection, normalcy, which can create emotional attachment and psychological dependency. According to her, anything counts. That's what the defense said. And then Combs provides a specific example in one of his filings that, quote, the evidence in this case will show, for example, that Combs financially supported his girlfriends. That does not count as coercion under the legal definition, but it would count under Hughes' definition. Suppose the evidence shows that after a fight, Combs apologized, expressed love, and bought his girlfriend a gift. That would not count as coercion under the legal definition, but it would count under Hughes' definition. And then Combs further argues that while Hughes provides a concrete definition of coercive control, in one of the articles she apparently cites, it's explained that coercive control is really undefined. And other sources don't help her either with her definition. So in other words, the defense says if she starts talking about coercive control, it's going to confuse the jury. There's a definition, the legal definition, he's charged with crimes like this, and her definition of it. So I think I laid it all out. Elizabeth, what was the discussion on Dr. Dawn Hughes, coercive control, interpersonal violence, and what was the decision?
Now, that's real deep because what they're saying is that the doctor have her version of what control mean, and then the law has its version of what control mean, and that they don't feel she should be able to testify and in front of the jury and speak on her definition of it because the legal definition is what he's charged with, and that will confuse the jury if they was to allow her to testify about her definition of control. All right.
So it was granted in part and denied in part. So pretty much the judge ruled they cannot talk about coercive control.
Okay.
That will be out when it comes to her testifying. And she can also not testify about the intent/motivation of abusers.
Okay.
And so what was granted, though, is that she can testify about delayed disclosure. She can also testify about memory issues. And we've seen it a lot in other cases where there are victims who have, delayed in disclosing what they went through, either with, a partner or even just in general from their.
In other words, she could justify why someone say that they forgot for 25 years, 30 years, 50 years. That's what they're saying that she could testify to.
Or alleged perpetrator. We've seen that before. And so to me, I'm not surprised that the judge ruled that way. He seemed to be fair in both sides, kind of being respectful, just to kind of make sure that nothing bad happens once this case actually starts. But in terms of interpersonal violence, the judge did say that the jury can understand what abuse is. The jury aren't too into the weeds to not understand what this means.
You don't need an expert.
Exactly. You don't need an expert to tell you. And so the judge, by the way, will monitor these lines very, very strictly. So there's not a lot of distracting sidebars. There's not a lot of moments where we have to, for example, start court late or something like that so they can argue about these types of things. So it seems like the judge, especially once Dr. Hughes gets on the stand, will be very strict in monitoring what can be said and what can't be said. But for now, it looks like no coercive control. We won't see those words uttered out of Dr. Hughes's mouth. No intent about or motivation of abusers, but can testify again about delayed disclosure and memory issues.
And that's important, right? Because a juror member could say, well, wait a minute, if she really was attacked or was a victim, why didn't she report it? Why didn't she go to the police?
There you go.
There's something, and our understanding has changed. And sometimes you do need an expert opinion about that. Okay, now I want to move on to this other thing. We talked about this last time. There's a lot of discussion about whether or not the prosecution can introduce evidence of uncharged acts, like alleged sexual assaults committed by Combs, allegedly committed by Combs.
Yeah, those are called overt acts.
From back in the day in this case. What did the judge say about that? Or what did the government say about that more specifically?
Yeah. So it was a defense motion. And so the judge granted it, but absent the door opening. So if someone opens the door, they can go ahead and talk about it.
Because the defense said it was so unfair to bring in all of this other stuff to prove the federal crimes. I mean, you're talking, they actually objected and said they would have to do all of this research. It'd be like a mini trial within a trial. Yeah. It's overly prejudicial. So what, in terms of, when you say open the door, you mean if the defense does something or Combs takes the stand, then they might be able to introduce it? What else did we learn?
So yeah, in a previous filing, the government said that at this time, the government does not currently intend to offer evidence of redacted unless the defense opens the door to these types of topics at trial. So for example, if the defense were able to or argue through opening statements or cross-examination that the defendant has never engaged in acts of violence, has never engaged in obstruction, or has never possessed a gun, then the government may ask the court to consider admitting certain evidence to redacted to respond to those arguments or areas of cross-examination. So again, if the door is open, then it seems like that's a whole nother story for a whole nother day. But somebody just has to open that door, and that could happen just at a blimp of a moment. Yeah. So we'll see how that plays out.
Defense has to be careful about what they say. All right, now there was a lot of stuff about charts, right? Yeah. And the way I understand it is, right, the government wants to introduce charts because there's so much evidence. Travel records, hotel records, financial records, phone records, text messages, emails, photographs. They can't go one by one, right? So if we can have an expert talk about a chart showing, I guess, all the evidence that was collected. I mean, what did we learn about charts today?
Yeah, and that's one of the things about federal cases or just cases in general, where especially in this case, things are just so complex. So it was a motion also in limine, started with the motion about timely disclosure, and it was denied as moot. And so pretty much the government and the defense came up with an arrangement that the government will provide those summary charts before openings. Now, what those will look like, how that'll be, and the time frame that we have right now, a little unclear because I can only imagine how many pages that is, how many documents that is. But it seems like the defense and the government have worked out a solution, and that solution being those summary charts that'll be provided prior to openings. And then more charts will kind of come in as more evidence and exhibits are put in as well, too. So it looks like it's not just a before openings type of thing, it'll continue on.
Yeah, and maybe just give an idea of what was collected by the government. Final point, there was discussion in their previous filings so much about other victims. So victims 3, victims 4. Any discussion about those victims today?
Yeah, not too much discussion about it. I remember seeing just in the court filings that the defense still objected to victim 3 and victim 4, alleged victim 3 and alleged victim 4, and to using pseudonyms when it comes to testifying at trial. Now, at the last hearing, the judge ruled that the victims 2, 3, and 4 can testify under pseudonyms. The defense says that they object to particularly victim 3 and victim 4. Now, as why they don't object to victim 2, that's unclear. That portion was redacted in their filing to the judge. But it looks like for now that victim 2, 3, and 4 will continue on testifying under a pseudonym. What that pseudonym will be, that's a wait and see. But
usually it could be Jane Doe.
Jane Doe, yeah.
And victim 1, we believe, is going to reveal her name. Again, we believe that to be Cassandra Ventura. And there's a lot of reasons why alleged victims want to proceed anonymously. You know, they're worried about harassment. They're worried about their safety. And
if some are like possibly known figures who have gone on podcasts and talked about their time with the defendant, then I can understand why they'd want to go under a pseudonym too. And Jesse, one more thing I do want to mention is that there was a moment in court today where there were issues coming up just about the indictment, specifically the defense questioning how the grand jury voted when they did their proceedings. And so,
and by the way, you mean like the new indictment?
Yeah, the new indictment, because there's been
three superseding
indictments from the one we first got back in September. And so I can see why the defense is a little frustrated here. They keep getting more documents. They keep getting more things filed against their client. And, you know, with 2 weeks now until trial begins, I can imagine why they're a little frustrated. But Mark Agnifilo made this argument, and he said there might be a constitutional issue when it comes to this, especially when it comes to his client going on trial for what the grand jury voted for, as opposed to what has been put in the superseding indictments that have come in afterwards. And so the defense says that so the judge didn't make a ruling as it pertains to this at all. The defense is going to find some cases that talk about precedent, that type of thing, and they're going to submit a letter. So we should see the filing for that by Monday. But as far as the government's response, they say that there's fair notice when it comes to adding in more incidents of forced labor. They say that as far as their argument goes, a bunch of records have come in that might not appear initially, that once they kind of dive into it more, they're able to add in more information into these documents. And that's what ends up happening in these types of situations. But the defense...
in one of their indictments, the superseding indictments, they focused a lot on forced labor, which is one of those underlying crimes of racketeering the criminal enterprise. And I remember it was like that they had people working like overtime hours. They weren't allowed to sleep, and they were denied certain things. And so it makes you wonder who is going to... It's one of those underlying crimes to support the overall racketeering charge, which, by the way, carries the most prison time.
Yeah.
Okay, so let me break it down, right? I'll let all that run so we get right to the point. What we're dealing with right now is Diddy getting ready to go to trial. They don't know if, Diddy's lawyers is saying that they didn't go to the grand jury to get the new charges in the superseding indictment. In other words, when they bring the complaint against you to the grand jury of your peer, they listen to that evidence and then they decide what you're charged with, and then they move it up the ladder. But now when they did Diddy's superseding indictment, they didn't go back down to the trenches to the grand jury. They just did it up there where they was at their level. So Mark Agnifilo, the lawyer, is pushing it, saying that no, he could only go to trial on what the grand jury of his peers said at the grand jury proceeding, not what you put together. What you put together was supposed to be transferred over to, them. All right, let's keep it moving. What's up, family?
What they do, boy?
What up? What it do?
Man, you don't never keep up with me, dog.
Yo, listen, man, I'm on a live right now. You're being recorded. You want to call me after the show? Or you want to give a shout out during the show? Your call. Let's ride.
Shout out to Brown Sub. Shout out to Carroll City.
All right.
Unique been showing me a lot of love. Y'all keep subscribing to him. You feel me?
All right.
And that's all I wanted to say, dog. I'll call you after the show.
Yeah,
though,
call
bro.
me after the show. One love, family. All right. So that's where they at. So his lawyer is saying that, you know, they didn't go to grand jury to get it, and they keep bringing on charges because you have to go through a process. You can't just say a day before the trial, here, we got 3 more charges. No, you got to go to a grand jury, and they got to hear it and decide if you violated the elements of the statute of what they presented to the grand jury to see what they do. You see how intelligent we speak on that? All right, still don't understand why he's in New York. Most of the alleged events took place in Cali and Florida. The Cassie tape is from a hotel in Cali. Well, he's in New York because that's where they filed under the Victim Survivors Act, and that's in New York. So that's like a safe haven for them to come get the Diddy stimulus. File the lawsuits, you know? Next question. Let's keep it moving. All right. Hefner got away with crimes because he was white. Diddy is going to prison. What y'all think about that? Put your comments up. Put your comments up. Give me your opinion on that. Next comment. Let me see where we at. All right. Now tell me where are they going to get a jury that don't know who Puff is? Where they under a rock, were they under a rock? Somebody let them know. But that's where we at, man. But so what do y'all think about that though? Because you know, Cassie put a motion in the other day to say that she didn't want to testify now, because you could imagine how that's going to change the whole trajectory of her life by her going up there testifying in this joint. That's going to be so crazy. It's going to be mind-blowing and baffling, you know? What time is it? Let me see where we at. All right. Oh, it's already 11:20. Been up here 30-something minutes, man. I just want to tap in and give you all that Diddy joint. Make sure you subscribe to my daughter's YouTube channel, Unique Mecca Audio. Keep it moving. At night, I'm going to try and give you all a little nightcap, you know, a little something like this, that the news run out, and we're going to ride out and unwind and have our little laughs and rides and do what we got to do, because that's how we do it, you know? They always take us down through drugs, women, guns, has been 100%, freedom, Southern District, New York, Lower Manhattan, Federal Court. You already know. All right, so now we're about to tap out, man. Been up here long enough and know that crime don't pay, but I like my outro.
Cheers, cheers, the crime, the crime, the crime, the crime, the crime. Fresh out the can of 26, he back on the strip, getting back in the mix. What he mentions a gift. You stand up 10 toes down, and I suggest you pay attention to this. Real. Take a little gully posse and put it in Harlem. He cut from the bottom, came up from the bottom. Drop the book, you should go and get it. The Instagram page and the YouTube, you could go and visit. Then you could consider yourself LinkedIn. Sit front row and get Jews from a kingpin. How he went through it, so you ain't gotta go do it. Did not pay attention would be stupid. Talking about a man that probably put your grandfather on. Probably the reason that him and your grams got along. A man that generated millions on the block, did his time, never squilling to the cops, make an audio.